Break. We have an update in the Treehouse Murder Trial out of Florida. You may recall, pro se defendant, and it was a hung jury. He's expected to be charged again by the state. They already announced that. Well, the judge in that case, who was forced to declare a mistrial in that case against Franklin Ty Tucker, has chosen to recuse himself, rather disqualify himself in Tucker's upcoming retrial. Judge Mark Jones filed a certificate of disqualification last week saying, "I feel that I am disqualified to sit and act as judge in the above entitled cause and therefore recuse myself from taking jurisdiction of said cause." The trial has now therefore been handed over to a new judge. Now, this all comes, of course, after the jury was not able to reach the verdict and whether or not Ty Tucker is guilty of taking part in a robbery that left one dead and another injured back in 2017. We've also learned there was a surviving victim. It was Tucker's star witness, Paula Belmont, and that was someone he was good friends with. There she is. She passed away earlier this week after having some health conditions. Still with us, constitutional attorney Chris-Ann Hall. Chris-Ann, let me ask you about this case and just tell me, have you ever experienced a case in which the judge themselves says, "I need to be disqualified, I can't hear this next trial"?
Yeah, actually, it's not common, but it does happen. It's a bit strange at this point, but nonetheless, judges have to recuse themselves for various reasons, and it's why it's an important option for a judge to maintain the integrity of the justice system. I think it's of the highest integrity for a judge to say, hey, there's a reason why I cannot sit on this case. I am conflicted on this case, and it is my desire, it is my devotion to have a fair trial, and to do that, I can't be the judge.
Yeah, I agree with you. It does happen. We're going to talk about it a little bit more. Thank you, of course, Chris-Ann Hall, for joining me on both of those cases. But on Tucker, before we go, I do also want to share today's thought from the bench. In Florida, a party can ask that a judge be disqualified for a few different reasons. For instance, if the party believes he or she will not receive a fair trial because that judge is prejudiced or biased, or if the judge is related to one of the attorneys, if the judge is a material witness in the case. These are all reasons why a party can say, please, judge needs to be disqualified. But the unique part here is that the judge himself asked to be disqualified, not recused. Those are two different things. He didn't say, I need to be recused because of this. They wanted to be disqualified. And a judge should disqualify themselves for any of those above reasons. The disqualification is really vital to safeguard and ensure judicial neutrality. While we don't know the exact reasons behind the judge's request to be disqualified, I sure do respect that he made a decision that he made was in the best interest of justice. Call a spade a spade. That's exactly what he did. Good for him.